All right, Jerry Mason, the Kickin Lawyer, and we're live for this is going to be a Kickin Lawyer show, I guess. Technically, not a law talk.
I think I ran the wrong intro. My bad.
Oh, either way, it's
I'll
fine.
fix it on the post version.
That's fine. So this is a special edition for those that are watching because of the big decisions recently. They keep coming. They brought another one today, but the Supreme Court keeps levying. And I wanted to do something like this. And to be honest, it was spawned because Friday afternoon, a person close to me, my daughter, called me. And she was very, very upset. And she does not hold my political views exactly. My children, I'm proud to say, were raised to think independently, and some of them don't exactly think the same way I do, and that's fine. In any event, she was just very bothered by the Roe versus Wade being overturned by the Supreme Court. And so we met that night, actually, to discuss it. She was very upset, very concerned, and I wanted to, address issues in general. Go ahead and have a seat, Malin. So I got a panel here we'll go over in a second of definitely experts in their field, and I just thought it might help people in the community to hear from our perspective at least why what happened, maybe, at least our reasoning on it, where the history is in Roe versus Wade and substantive due process rights and how all that plays in. And then if you have any specific questions on it while you have three lawyers and a nurse on here, we'd be glad to address them. And we've already had a couple of viewer questions that we'll get to. So first, the panel that's helping me out is, of course, my lovely bride, Madeline Mason, who is a nurse and then also just graduated nurse practitioner school. So she's very knowledgeable on that end. And then I have on the other side over here, we've got Jeremy Armstrong, who's also an attorney in the area. He has his own office in Ripley. I think on TikTok he's like the corpulent counselor.
It means fat.
I didn't know what corpulent meant. Anyway, but look, just so everybody knows, I have a lot of respect for Jeremy. He's super brainy smart. So that's part of the reason I wanted him here. I bow to him on tons of legal argument issues, that especially case law driven. And then my law partner, Kim Daugherty, who's a family law expert and just all-around constitutional scholar. I found out today she's also a big George Washington historian. So anyway, and we all have a very vested interest in this, and not just because we're lawyers, but on how it affects us, our clients, our children, etc. So I think what we'll do is I'm going to let, again, I kind of wanted the historical background, and I know both of you have done research on it. So I guess, Jeremy, maybe I'll start with you on, I guess we could start with who knows the background, Roe v. Wade, the sort of the fact pattern, what the issue was, and then obviously it led to a string of cases that people are now nervous about.
Well, I'll start if you want.
Sure.
All right. So, kind of the seminal case on it. Now, before Roe v. Wade, we had Griswold v. Connecticut. And that one involved contraception for married people. And that is where they basically read into the Constitution this right to privacy. Privacy between people and their doctors, people in their homes, things like that. And what they did, they based this on the idea that if you read the entirety of the Constitution, there are certain rights that aren't necessarily spelled out, but are derived from the other rights that are explicitly spelled out. And they call them penumbras. They fall under the shadow of those other rights. And privacy being the particular one of those. So Griswold was about contraception. It was in 1965. Now you had Roe v. Wade in 1973, which involved abortion. And the decision that came out then was based on that substantive due process. And it basically said you could pass laws regarding abortion, but the further along the pregnancy went, the less restrictive laws could be, or more restrictive laws could be. So the closer a baby was to viability, or an infant was to viability. So the first trimester laws couldn't be very restrictive. Second trimester more, third trimester even more so. Proceeding from that, you have Planned Parenthood versus Casey, which actually came in 1992. So it wasn't, in the grand scheme, that long ago. And instead of, it did away with the trimester system and went with more of a viability-based system, wherein abortion restrictions are more based on the developmental level of the child. But all of this goes back to the substantive due process, and that kind of goes to what is substantive due process. We know what procedural due process is, and that is the government must follow certain procedures before they can deprive you of rights. You know, before you can be arrested, they have to have probable cause. But substantive due process is they can't violate your rights if there is one of these rights that they've kind of formulated through reading the other amendments.
I think it's also important to talk about how this case came to be. This had to do with Mississippi's Gestational Age Act, which provided that except in medical emergency or in the case of severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. And that was Mississippi Code annotated section 4141-191, and that was the law that was being challenged by and the Mississippi Department of Health stated, yes, we can have this 15-week sort of cutoff. And so it was brought before the court, and it challenged Roe. I think that the people who challenged it may or may not have realized that, well, here we go. We could just totally, it could be, the whole Roe could be overturned just on this, because they were only asking for a 15-week restriction. And I say only, but a lot of states have started these different time periods of where they're going to cut off abortion services. So it's been a concerted effort to overturn Roe by making that gestational period less and less and less. So, and then this is what happened. Roe was overturned. And the petitioners defended the act on the ground that Roe and Casey were wrongly decided and that the act was, is constitutional.
So let me bring that, because see, y'all are also smart, and I'm going to be the stupid guy here that sort of dumbs it down, I guess.
Well, you should say we do have Brian Huffman in the...
I know, he's all making
Who's-
faces at us.
Shadow
Brian is scared,
Yes.
though, to be on here. All right,
Which
here's
Brian
what,
should put his
here's what
two
I wanted to
cents
just
in.
circle back, because both of you are obviously right. But one thing that I think needs to be clarified, because I've heard people say they, quote, took away my rights. This is what my daughter said, right? That this is a takeaway of their rights. And one of the things I think needs to be pointed out is that there is a difference between fundamental rights, fundamental constitutional rights that are listed in the body of the Bill of Rights and arguably in sections of the Constitution, and then there's the substantive due process rights that we consider constitutional rights, but they're basically rights that weren't outlined in the Constitution. It's kind of like Jeremy said, they're outlines that have been basically rights that have been sort of read in to what, well, this is what they meant. Right to privacy means this, right? So just to be clear to the viewer, because I think that's a point of confusion, is these cases they're talking about sort of developed this area of law that gave people rights that, maybe we feel we should have had, but you didn't have, at least not under the Constitution. So it created that. And one of the arguments, and this is an argument that, we can discuss today, is that this really was, and Jeremy and I discussed it Saturday morning briefly, he actually brought the point up, that this was really the Supreme Court legislating from the bench, so to speak, that maybe these rights there should have been an amendment to the Constitution. Maybe there should have been a different vehicle for these rights to rise or be recognized. And so y'all just tell me this, I guess we can go in on the overturning of the decision. I feel like part of the justification of it was, and this is what they articulated, was that they kind of felt like the Supreme Court didn't have grounds to really levy that decision when they did. And that so this was a corrective step by the current court, even though it's 50 years ago on these cases, to right the ship and say, look, it really wasn't our place to say this. And so they didn't overturning Roe v. Wade does not outlaw abortion. What it did is return the decision on that to the state. So
Yes.
Anyway, y'all can comment on that.
10th Amendment.
Yes.
Yeah.
It's exactly what that did. Abortion's not been it has and it is and it isn't. I mean, you've got to look at it both ways. Yes, the Supreme Court did not, quote unquote, outlaw abortion. They didn't. What they did was they returned it to the states and state legislatures to create laws for that state. Now, certain states have trigger laws, which mean that abortion may not be available in certain states now. And we may look like a patchwork of states that have different laws as it regulates abortion, or whether abortions will be, accessed in a certain
Same
state.
thing with medical marijuana
It-
or marijuana
Right. So exactly. So it's going to return to the states for each state legislature. I think that there are some, and I'm going to play devil's advocate both ways. I don't like to put my opinion out there. I'll be honest. I don't trust the government. I'm pretty libertarian, I'd say, but I think that I've heard from some people who have, what are kind of where are we going from here? Because we have these concerns about right to privacy. What does that mean? So, I think it's a valid question.
Well, I think a lot of the concerns came up, and I'm going to ask Madeline a question too on the medical side here in a second, but I think a lot of the concerns came up from Clarence Thomas's concurring opinion, where he specifically brought up that basically that whole series of cases that use the same reasoning would need to be reevaluated. He didn't say they were void on their face because of this decision, but he inferred that the reasoning was invalid, basically. And that's what's got a lot of people scared, because it dealt with right to contraception, right to interracial marriage,
Yes.
right to same-sex marriage, etc. So those decisions now are at issue, and it's made people nervous about it. My question real quick to Madeline, though, and this is just because this is something we probably don't know. Under the way the law was prior to, I guess, Friday, the viability was a big component of whether an abortion could happen in a lot of states or not. And I've voiced multiple times on here my personal opinion that to me, I try to take the religion out of it and I focus on the legal argument. And to me, the legal argument is if the fetus is viable, it has fundamental rights. You can't abort it because it's a living being and it has constitutional rights. That's, to me, a clean, easy way for me to view it. Easy for me, obviously, because I'm not stressing over being pregnant right now, obviously. But my point is, medically, is there a standard of what's viable for a fetus?
I mean, really, an obstetrician is the.
Hold on a
expert.
second. Josh, is her mic on? I can't hear it.
Am I on?
Yeah, it's something to do with when we had to swap them out, I'm sure.
You may have to lean closer to me. We're married, so it's okay.
No COVID here.
We got these new mic stands that actually work, too, so now I can't hardly move it.
Now, can you hear me?
Yeah.
Okay. So, obviously, an obstetrician is the expert in this subject matter, but I mean, you really get into that abortion is kind of a catch-all category, right, in the medical world. So, when you're talking about abortion, you're not just talking about one thing. So, you can have somebody who thinks of an abortion as the termination of, of a infant, of a fetus that could be viable outside the womb, but then abortion also covers a lot of other things, like a DNC is technically coded as an abortion. You have non-viable fetuses that your doctor can decide you need a medical abortion for. So, some of the worst cases I've seen are when an infant has a type of encephalopathy where they don't grow a brain, and the fetus, the unborn baby, doesn't have a brain, and so when they're born, they can't even pass through the birth canal. You can't survive without a brain. I don't know if
That's questionable.
people are going to argue that or not, but so the pregnant woman can't even have that baby naturally. They have to have a C-section, because if that baby tries to come out of the birth canal, it could kill the mother, because there's no brain to make that head-shaped concave, and that's how the baby passes through. If you've never seen childbirth, YouTube it, you can figure it out. But
Well, let me ask you this. Is that mic on now? We're speaking to that mic.
Try that mic.
check.
Say it again.
Check.
Oh, keep messing with it.
I can't tell. Could you tell if it was on? I can't hear it in my...
It's the cables itself. It's
Okay.
'cause we had
All
to
right.
swap them out.
In any event, what I was going to say is, what about in that instance, and I asked this because I don't know the answer to it. Now, I'm hearing that, Josh. I got static when you're doing it, but I don't hear the mic. Maybe the mic doesn't work. You can plug one of those gold ones in.
Yeah, give me an
They're
old one.
buried.
Yeah.
somewhere.
Anyway. All right. Well, what I was going to say is, and I asked this because I don't know the answer, but if it's in the medical setting, and let's say you have evidence in the medical setting, and I don't know if this has even been discussed or if the decision changes what you guys would do medically, but if there's something up with the pregnancy that's a risk to the mother, does the doctor still go ahead and do the procedure? Like, what's the standing order on that? Let's say the mama comes in, she's incapacitated, there's nobody else to make the decision, and the doctor has to make a decision. Is there a standing, medical practice, standard of practice for that?
I think what you just asked is if the pregnant woman comes in, are you just going to do an abortion?
Well, I'm asking if the doctor would do it. I guess what I'm asking is legally, again, I ask because I don't know the answer, is if something's complicated, there's a complication. Like a lot of people, like one of the questions that I got asked by this person close to me that I said spawned all this. She was concerned, she was saying, I was talking about my daughter. Jade said, well, Daddy, this is going to affect your granddaughter. She's like, if I have a daughter, this is going to affect your granddaughter, and now they're taking. She was saying that they're taking a right away from my granddaughter, from my daughter and my granddaughter, arguably, right? And she was worried about stuff like that people would be which I don't know that this is the way it would go, but I'm just curious in the medical field how y'all look at it on if somebody needed there was something going on with the fetus, and it was the fetus or the mother. What is the medical? Is there a weighing of those factors for the medical profession, and will they still go ahead and do an abortion, or is there focus on the fetus?
Well, so in the medical profession, you look at the mom as a patient and the fetus or the infant as a patient. So it's two separate patients. So anytime a mom presents to a labor and delivery department, you have two patients there you have to take care of and keep
At what? So when does
them
that
both alive.
When does the fetus become a patient then medically?
Very tricky question.
Jerry, can I
So
just
it's-
jump in and just say something? I don't think it's going to matter.
It's
Yeah,
always
it may not matter.
And it's not going to matter because this is the root of what there are people who are concerned because this is exactly what we're going to. Each state will legislate that. It will no longer be between a patient and a doctor. That's the whole basis of
And
this is
that's
the right
what-
to privacy between a patient and their doctor.
Exactly.
And that was what Roe was based upon, is that the right to privacy was something that a woman had with her doctor so she could choose. So now, and this is me playing devil's advocate, this is something that each state will legislate. For instance, I go back to the original, the original Mississippi Gestational Act. They were going to allow,
Check.
in emergency or the case of severe fetal abnormality. Then you have to ask yourself, what is a severe fetal abnormality? And you've got Mississippi that had, I think it was one abortion clinic. So it's not like you had a bunch. And then I know that I think I read somewhere where there's fewer obstetricians in Mississippi or somewhere else.
Oh, sure. I mean, the South is notorious for having, limited services for rural health per capita. I mean, that's just, that's not
Right.
limited to this specific thing, primary care, you name it, pediatricians. I mean, we just don't have as many.
So it's not going to matter because this will now be legislated. I mean, this portion of women's health will be legislated.
Yeah, and I think the biggest concern, like you were saying, what Jade said, is how far does it reach?
Yeah,
What's
so
the reach here?
let's go
'Cause
through
we're
that.
talking about more than just abortion, right? We're talking about reproductive rights in general.
Well, potentially. So let's go into that a little bit. Let's talk about what are the other cases, these other substantial due process rights that you guys feel like may be affected by this in
I
the
think
future.
birth control. I'm going to jump in there and tell you birth control. And here's what I tell you. We have different kinds of birth control. Not all of them are the same. An IUD, lots of women use it. Lots of women who've had cancer, cannot use any kind of birth control that has an estrogen, and so they may use the standard IUD. Well, the purpose of an IUD is to prevent a fertilized egg or prevent a pregnancy from taking place. Under certain states, that's a potential issue. You've got, when Jeremy talked about the original case, which I love to call the birth control case, but it had to do with, what they ruled was that married women could have access to birth control, not unmarried women. It took another 10 years or so before unmarried women could have access to birth control. And the truth is that, there's been a long history of women getting abortions, getting birth control.
I mean, that sounds kind of preposterous to us today that you couldn't call your doctor and say, hey, I need my birth control pack for next month. But that's, what some people, especially people that remember this time frame and, are elderly now and had to be activists for these rights, that's kind of what they're going back to and what they remember is, it sounds preposterous to us, but that's what they lived in, is that they didn't have access readily to the health care that they desired. And so, I don't know if the decision, it could go one or two ways. This decision could help in the long run and make it more of a doctor-patient conversation, depending on how the states regulate it. But it could go the other way extremely, and you could have states that just say, no all the way across the board, and this is illegal, and
Well, I think that's
and
what
criminalize physicians for making
those choices.
decisions that are
Right.
best for.
And I'll also
the
bring up
patient.
the fact, too, that most abortions now are not done surgically, that they are now done medically. So you can take a pill and have an abortion. So now, in this day and age, so much can come across the internet, can be mailed. So what do you do with someone who has received a medical abortion and, or they've gotten a pill from somewhere else and they're having complications? They go to a doctor in a state where abortion is not legal. Is that woman subject to, some sort of criminal, that's what, we're going to, I think the argument is that, women and their doctors may face criminal action for
Well, it's
something
kind of like
that.
a separate argument that's has to do with women. Is right now a big topic is women and prenatal health care, and women seeking access for prenatal health care that do recreational drugs. I mean,
Right.
it happens. It's a thing. Women do recreational drugs while they're pregnant, and then they feel stigmatized in certain communities to seek prenatal care because they're scared they'll get their child taken away from them from going to a prenatal visit and knowing they're going to get a drug test. So they just don't get prenatal care, and then they show up to deliver, and there's all kinds of complications that can arise because they don't get that care. So, I mean, I think it's kind of all in the same line of conversation. Is when you limit on one side, you're going to have downstream consequences from limiting services.
Well, and I was going to let you comment, as I think you're fixing to comment on what I was going to say. But, so we were talking mostly about the female effects, but Jeremy, maybe you can speak to, there's some other cases that may be affected by this that affect everybody.
Well, you've got a lot of people were talking about the contraception case. You're talking about also potentially the gay marriage case, Overfield v. Hodges.
Yes.
It's based on, that same right, right to privacy that comes with marriage. Now, people are going to argue that one's not quite the same because you still got an equal protection argument there. And that is, the principle is, you've got due process rights, you've got equal protection rights. Due process is the government has to go through the steps before they can deprive you of some right, before they can take a right away, be that to abortion, contraception, whatever. But when it comes to equal protection, you can't treat someone differently based on their age, sex, race, national origin, gender, things like that. So the concern would be things like, I'll say, gay marriage. Now, people have made a big point about Thomas, who authored this concurrence, talking about these cases he would challenge. He is in an interracial relationship. He is most famously the oldest sitting black justice right now, but he's married to a white lady. And they're like, well, is he not going to challenge Loving v. Virginia because that would be his own marriage?
And that's the interracial marriage
Right.
case, yeah.
Now, that one was decided not only on this substantive due process marriage right, it was also done on the equal protection because you can't discriminate based on race. So that one, might be safe. And you might be able to argue the same thing for Obergefell v. Hodges if you consider homosexuals, people of other sexual orientations, because I know we can't just say homosexuals now. There's now a, spectrum of identities. You say the same thing about that if the courts or the Senate or whoever, the Congress, were to decide that they are, a suspect class, and that doesn't mean that they're bad people. It just means that they have special protections under the law. Then they would be protected under equal protection.
You know what's
I don't think you
crazy?
get that far anyway. I think they're under the equal protection clause regardless. The difference between those types of cases and an abortion case is now we're talking about a potential human life that's separate and apart from the mother.
Yeah, but
And that really is the question with the trimesters and the viability
Yeah.
and things of that nature.
but this is what's interesting is that the court held that the 14th Amendment's equal protection clause did not apply to this because they say that states' regulation of abortion is not a sex-based classification and thus not subject to heightened scrutiny, which I think is crazy because the only people having abortions are women.
Well,
You know?
that brings up another very good point I wanted to make that's controversial. So let's open a controversial can here. So for months now, we have been arguing over what is a woman. We've been arguing, well, not us specifically, but the public over, well, I'm a man. I'm born biologically a man, but I'm going to say I'm a woman now, right? And I'm female, and I'm supposed to be called female pronouns, and I'm a female. And it was interesting to me that in this last week, a lot of the people that tended to have that perspective, and I'm not saying which is right or wrong, it's just this is interesting. All of a sudden now, we seem to know what a woman is. It seems to be that definition is clearer today than it was before Friday.
According to the court,
Well, I don't know.
They don't get that heightened scrutiny that this is going to be reviewed as other health and safety measures.
Well, but I don't know if that's necessarily true because I think this decision could overlap into who can, contraception and estrogen and progesterone replacement are there's a very narrow jump between those two. So if you're limiting, if it did jump into some states limiting contraception availabilities, well, then that is a direct line into limiting replacement therapies for hormones too, because they're all that's all a category together of the drug classes. It is the same thing. You're prescribing estrogen, you're prescribing contraception to those people that need the hormone replacement to transition. So I don't know. I don't think it's a separate conversation.
Well, equal protection would be anything that applies across. You can't. It's almost like the civil rights deal, right? You can't discriminate against gender, race, etc.
National origin.
Yeah, and so another thing that comes up when we talk about either contraception availability, these drugs for hormone changing, and another thing I want to talk about in a second, so y'all can be ready, is the basis, the test, rational basis, the scrutiny, the level of scrutiny that they use, because I think the viewer might find that interesting, and it's still even confusing to me after law school. But one thing I was going to say, another thing that brings up is, and understand this, I brought up the scrutinies because I think part of the difference in what I'm about to say is it would be under a different level of scrutiny, and it's not an equal protection thing for sure. But if it's your body, your choice, why am I forced to take a vaccine? You know what I'm talking about?
I was going to bring that up too. Yeah.
It's a similar thing. Is that over the last couple of years we've been, and I took the vaccine, but to some degree I was almost guilted into it. It was like a forced thing, and I get that that's a.
You're a grown person.
But I think the
Nobody
court just
forced you.
ruled on that. That
Yeah, well, this court did. Obviously, this court is a
yeah.
little different. My point, though, is that here's my point. People that argued in the last 2 years, and I'm not trying to point people out and lump them into a group because everybody's going to come back and say that's not accurate, right? But the reality is a lot of people that are now very, very upset over the Roe v. Wade decision because they want to argue my body, my choice, were arguing everybody should get this vaccine a couple of years ago.
So there's something of a difference there, and while I have never been pregnant, I do have family members that have been pregnant. And I have seen the effects that pregnancy has on, a woman's body, on, her physical health, the risks that it puts, the female body under. And, those are nothing to laugh about. Yes, mammals in particular, have been giving birth for the past umpteen million years, but you've got this issue of pregnancy is sort of inherently dangerous. One, you've got things like preeclampsia, which is unfortunately way overly common around here because we do not have the best health care around here. We have a lot of obesity. You have gestational diabetes that's sky high around here.
High blood pressure.
So the risks on a vaccine, yes, there are going to be negative reactions, and you've got, the people who think it's a microchip. There are going to be negative reactions, but the negative reactions to a pregnancy versus possibly the negative reaction to a vaccine, one, it happens much more frequently.
Well, that's interesting you should say that, because I think that goes towards the history basis behind the Supreme Court justice. They bring up the history of this case. They bring up the history of women's health care, and they literally said that, the right to an abortion is not deeply rooted in our country's history. Now, here's what I'm going to say to this. Again, I'm going to play devil's advocate, but I'm going to say one of the reasons it's not deeply rooted, quote unquote, in our nation's history is women's health care is not deeply
Well, it's
rooted.
not just that. You couldn't keep a baby alive
No.
in 1730. You
No,
didn't have
and-
immunizations. You
No.
didn't have.
You relied on a midwife. We have a greater history in our country of dental care than we do of obstetric care in our country. So if you look at it that way, of course, we're not going to have this long history of all this, but I'm not going to say it didn't exist, because as long as there's been pregnancies, there have been people trying to rid themselves of unwanted pregnancies. That's been throughout history. So you can't really say that. I did feel like in this opinion, the court cherry-picked our nation's history. If you look at the Heller case, which had to do with, gun laws, which was the seminal, right to bear arms case, that case, what the justices discussed was the word militia. Did we need a current militia? Because now that we had a police force that could protect our interests, therefore citizens may not need guns. And then they've decided no, because this was, deeply rooted in our nation's history, and we've just had a gun control case that the court decided upon. I think that you're looking at two different things. I think when it comes to women's health care, no, it's you're not necessarily going to have this written health, but it's always been there.
Well, I think another important point, too, is the Constitution is not for the citizens. The Constitution is for the government. It's to tell the government what it can't do, what it can't infringe on. It's not to tell the citizens what they can do. So, Jeremy wants to say something to that.
Well, that's a really good point. A lot of countries' constitutions are what we would call positive constitutions.
Yes.
They are, the government shall provide health care, shall provide safety, shall provide X, Y, and Z. Our Constitution, in contrast, is what we call a negative constitution. It, instead of granting the government power, it limits its power over the citizens. So, in reference, you said, they cherry-picked history. The standard of review on this case,
It in the original Roe v. Wade.
they did, but the standard of review on a substantive due process case is there a fundamental right, a substantive right there? Is it privacy? Is it, I won't say commerce, because that one was done away with after the Lochner era. But is there privacy? Is there something like that? And then is there a historical protection in our country for that? And they went back and they looked through, the statutes since the 1700s forward, and they said, historically, abortion has been outlawed, and there has been, prosecution of women who attempted or had abortions. So they said, obviously, there has been this idea that abortion is bad, and there should not be a right to an abortion.
And I don't think that that's really necessarily true, because in our country, if back before Roe v. Wade, if you were a woman of means, you could get an abortion. There were doctors who were performing abortions, and it was,
They were illegal in the law.
they were illegal, just as it was illegal for married people to get birth control. But married women got birth control before we even had a Supreme Court case. I mean, that case in and of itself was a little convoluted, because they went out of their way to open a Planned Parenthood office and to distribute birth control so that it would go before the court. So in this, because it was so widely accepted that it was just on the books places. So abortion has been available for a very long time, even in the Roe era. It's just, it was a matter of really making it where everybody could get it, I guess. But
Go ahead.
So, kind of referencing that, Tennessee's trigger law, the big concern is all these trigger laws that are going to go into effect within a few days of this decision. Tennessee's law has been on the books since 2019, and it goes into effect 30 days after the Supreme Court overrules Roe v. Wade and Casey. And actually, right now, they are trying to push through the court to get it enacted even faster. Because they think there's going to be a rush on abortion clinics. But the statute is 3915-213, and it basically says that any person who performs or attempts to perform an abortion commits a C felony. The affirmative defense to it would be if they're a licensed physician, and the physician, on their good faith medical judgment based on the facts, said that the abortion was necessary to prevent the death of the pregnant woman or to prevent serious risk of substantial and irreversible impairment of a major bodily function of the pregnant woman. And they do a specific carve-out that mental health is not one of those issues that the provider can account for. So there's kind of a carve-out there, and women are not prosecuted for illegal abortion, but they would be prosecuted for conspiracy to commit illegal abortion.
So there is no rape or incest clause in Tennessee?
Not that I've seen, no.
Well, so this opens up another question. By the way, the whole the shot thing, I don't want to undersell the abortion issue, obviously, and I don't mean they're equal at all. I just mean that when we rationalize that, the analysis is similar. You see what I'm saying? But what I was going to say is, like we talk about, the Constitution is really a floor. The Constitution is saying, look, government, this is the rights these people have. There's, you can't infringe on these rights. Like Jeremy was talking about, it's a negative Constitution. And this gets into a bigger debate over how we interpret the Constitution today. So what I mean is, some people say, and I've told this before, but, my buddy Dave's a black guy, lawyer. He and I are really good buddies. We talk about stuff all the time. And I always bragged about, like recently, especially, I'm related to George Mason. And George Mason and his Constitution, George Mason owned slaves. And I was talking to Dave one day about how the Constitution, it was so amazing that they made it when they did. It's almost like all these geniuses were together, and it's such a wonderful document. And he said, Jerry, my great whatever it is, grandparents were slaves when they signed that. And then it hit me that I had not actually thought about that. That, man, if it stayed like it was then, women couldn't vote, women didn't have rights, couldn't own property, black folks were still enslaved. I mean, all these things that are clearly atrocities existed. So I say all that because of this. So this is morphing into people on the gun debate argue that it should be interpreted differently because the founders didn't anticipate we would have, weapons of mass destruction. And then
typewriters, computers.
Similarly, the something like this, these rights that, maybe they didn't even think about it then, and we've evolved and morphed as a society. So anyway, I open that for discussion on how we should interpret the Constitution today.
I have a question for you.
Oh, okay.
Where's your position on the 10th Amendment and the police power of the state, as opposed to the federal government's negative Constitution? 10th Amendment, talk amongst yourselves.
Well,
you can't drop a bomb like that.
Well, let's come back. We'll come back to Brian's drinky
that
10th Amendment question.
Very heart of this decision.
Well, you're talking about executive powers.
Here's what I'll say.
Feds versus the state.
That's what I was about to ask them. Isn't the 14th Amendment really to tell the federal government to be able to hold the states accountable for infringing on the citizens' rights in that state?
But that's limited to the rights, whether it's under the 14th, whichever application you're trying to get to the states, it's still based on what is in the Constitution.
Well,
and the Constitution is a limited document.
But I think you're moving backwards. Then you have to go back and say, well, when they wrote it, women didn't have the right to vote, and women didn't have. Are we taking it? Are we taking?
I think you're going off in the left field on the tangent, because realistically, the Constitution limits the federal government, period. The federal government has expanded way beyond the Constitution. However, we're here now anyway. But the 10th Amendment says all powers not granted to the federal government are reserved to the people and the states respectively.
But
people can always change it all they want.
Yeah, but you can amend
the federal government cannot step in where it does not have power. And
yeah.
The 10th Amendment has.
Go ahead.
But here's the problem, and I think this is why all of this confusion is. This is the first case that we've actually ever seen where our Supreme Court has conveyed some sort of right upon people, and they giveth and they taketh away. And I think that is what is causing so much concern amongst people. Is this is the first time we've ever seen a court just say, like, there's the legal principle of stare decisis, and our courts have.
Scott and stare decisis.
I understand that, Brian, and they did go through that, but this is within our lifetime that there's the principle that when the court makes a decision, they will stick with that decision given the information they have at the time, the historical basis, all of this. Just like, and I understand what you've said, but they've said that those cases that held that blacks and whites should be segregated were terrible. They should never have been there. And I'm not going on the moral principles on anything like this. What I'm saying is,
reconcile that and stare decisis.
I'm not reconciling
you can't have
it
one way and then have it the other way.
They discuss this in the opinion in that they're saying this doesn't apply here because it was erroneously decided. I think my concern, just as a citizen, is there's so much politicizing of, and we're so polarized today that this court seems very politicized. There was some talk that Justice Roberts would have tried to get something sort of halfway to get people used to the idea of rolling into something more restrictive, that they would uphold the 15 weeks, not just take, it off the table and return it to the states. And I think that's where it's such regardless of how you feel about the issue, it was shocking. It was a shocking decision.
Right. We don't want our reproductive rights used as a means to get somebody to the polls, right?
Right.
We don't want it to be what the midterms are decided on this year.
So, two things. One, you mentioned that they giveth and they taketh away. What's interesting about that is the first delineated substantive due process right was the right to contract. Mm-hmm. It was the commerce right, all right? They said you can't deprive somebody of property, freedom. And the first cases about that, first one was the freedom to contract. The second major one was Lochner. And that one was about a baker's right. I believe it was a baker. His right to work a 10-hour day if he wanted to. Mm-hmm, mm-hmm. He was a private business owner. He wanted to work more than 10 hours, and it was against the law at the time. And the Supreme Court said you cannot legislate his right to contract and to run business. And that was all, basically overturned in the 1930s with FDR's court, where and now if we went back to the Lochner era, people would have a conniption fit because that would be the end of labor laws.
Yeah, and I'm not far off from what you're saying. I'm saying that it's just, if you look at this from a modern day perspective, it's very difficult for us to think about how it was before Roe, because in that time, in before the 70s, it was different from state to state. So it's and the numbers are different. I looked at some data recently on, what is the data on abortion now? We're actually, the latest data shows that there aren't as many abortions being performed as much as they once were, because we have so much more education now. Contraceptives are readily available. We've got some of this stuff. The large majority of women, they're not teenagers. They're women over, I think it was 20, they're 20 to 29 and over 30 who already have one child. And so when you think about that, people say, well, you shouldn't use it as birth control. I agree. I'm just saying that, some of these were due to health decisions, other things. I don't want to get in the weeds about that, but it's just, I think that historically we know different things now. Our culture is different. During that time when Roe was decided, women couldn't get a credit card without their husband's signature. We're just in a different place.
Well, but my point on this, here's my point on open this door, right? And this is sort of, I try to simplify things, is I agree that in the beginning our Constitution, everything was different. The time period was different, the people were different, the view on things were different, right? And that we've evolved as a society, I would think. But our founders did give us devices to fix that. That's why there are amendments. That's why we have amendments. And so I feel like, and I'm not trying to defend necessarily what the Supreme Court did here. I'm just really wanting people to understand how they did this and sort of what their reasoning was, because there's a lot of backlash. Like you said, it's been politicized. And I feel like there's a lot of people really, really struggling with this. And I just think it's important for them to sort of understand a little more detailed way of the background of the cases, where we are, and then obviously where this could go. But here was my point. I think that this Supreme Court said, you know what? This should not have been decided by the Supreme Court. This is something that these lazy legislators we had should have addressed. It should have been addressed. You know, you can amend the Constitution. We've done it before. And if it's that big a deal, you need, and this is again why people should vote. You know, and another point I was going to bring up is, if nothing makes you think that voting is important, this should, because, you know, this is a reflection of Trump appointing several Supreme Court justices. And so there's people that are fussing, and, you know, you've got almost as left-leaning a Congress and a presidency as you could have, and now we've got the Supreme Court just daily throwing out these conservative opinions. I mean, today, what was the one they did today? It was the right to prayer. The prayer, the coach was praying on the field, and the Supreme Court said that was okay. I mean, that's a very conservative take on that. My point is, like, I just feel like the Supreme Court, whether what they're doing is correct or wrong, like you mentioned, they're just trying to fix what they feel like was an error from the Roe v. Wade court.
So there are plenty of, I'm not calling myself a constitutional scholar at all.
Yeah, I'm not either.
But there are plenty of constitutional scholars and other people who are just as, if not better informed than I am on it, who have said that, and on both sides of the aisle, who have said that Roe v. Wade and even Planned Parenthood versus Casey are terribly reasoned opinions.
Ruth Bader Ginsburg said it.
They wanted a result, and they worked backward to get it. Now, you could say the same thing about Heller. You can say the same thing about McDonald v. Chicago, which applied Heller to the states. You could even say the same thing about the recent Maine gun decision, New York. I'm sorry. So you could say the same thing about those, but ultimately, it was not a well-reasoned argument. It was a work-backward argument.
But don't you think they did that because of stare decisis? Because, you know, in the Casey decision, do you feel like they did that in order to preserve Roe, but to kind of throw a bone to, you know,
so when Casey,
what they were agreeing? I mean,
Casey, everybody on the right, when Casey was coming out, thought it was going to be this decision.
Sure.
They thought it was going to overturn Roe, and instead they left Roe in place and put a few more restrictions, changed the analysis a little bit. But we've got, the situation now where it's back to the states.
Well, but what about the separation of church and state here? Because some...
Does not appear in the Constitution anywhere.
It doesn't. That was dicta.
That was dicta, and it was a letter from Jefferson to the Southern
Thank you
Anyway,
very much.
Madeline,
Yes.
What were you saying?
There is no such
I don't
thing as
remember now.
separation of church and state.
So
Pennsylvania was founded on a religious.
We have freedom from.
Brian, if you want to be on the show, you need to come get on a
I
microphone.
think he
So-
should.
There's people
Brian,
trying to
why don't you
watch
come
us,
in?
so they
Like
can't hear.
bombs,
They
throwing
can't hear
cars.
you though. They can't hear
So-
anything you're saying.
we can look at the religious side of the abortion debate briefly, right, Jerry?
Well,
can
but
we?
what about the people...
You can look at whatever
I
you
don't
like.
think
What
they're-
about people
yeah.
who are in a religion that their religion does not necessarily that their religion would condone having an abortion if it was for the mother's best interest? Like some sectors of Judaism don't want the mother to be at risk, so they would say it's okay. So at what point, like as a provider, we'll ask the patient, we'll go with whatever the patient wants based on their religious perspective. We're not going to overstep their religion. So, if they want a blood transfusion, we're not going to make them have
Right.
one. So if you are in a religion where your religion says, like, you should do this, where does that come into play here?
Christ signage.
Well, then you, presumably under this new schema, you would either go to a state where you can do that, in which you're looking at an economic difference here. If you're, if you make $15,000 a year, if you're working minimum wage, and your religion says you need an abortion in this situation,
There'll be
it's going to be
disparity.
tough to go to a state that allows abortion. But, you know, I kind of read through the statute here. I think there will still be plenty of doctors who are willing to shoehorn in these issues into that statute.
I don't see any. I mean, there's such a stigma on abortion and abortion providers to where it became its own entire industry. I don't think, I really don't think that's going to happen. I think it's, you know, I'd love to talk about the unintended consequences of this decision, because I think that there are going to be a lot of them. And I don't, you know, this, and I go back to, you know, what this was decided on was, did the 14th Amendment provide liberty? The whole, and this is what they talked about, that this has nothing to do with it. This was not, yes, like Brian said, it should go back to the states. It's already been at the state level. We had this pre-Roe. You know, states made their own laws as it related to abortion. So that's what we will return to. Abortion will become, again, something that people of means will be able to do. This will not be something that will be available to someone, because you will have to travel. You will have to go somewhere else. You will have to have the money to do it. I mean, you're going to have some of that stuff. And I don't want to make light of it, because it's a horrible position for anyone to be in. And I would never wish this on anyone. And what bothers me about the opinion a little bit is, well, I wouldn't say even a little bit, is that they said 14th Amendment refers to the liberty interest that protects a particular right. And they were, you know, when we talk about the 14th Amendment, we talked about slavery, it was, what did that mean to the individual liberty? Well, you don't have liberty over your body. You don't have liberty over, you know, what you can and cannot do. So, you know, here we have something that in the Roe case, this was deemed right to privacy because it was supposed to be between a woman and her doctor. This will not be between a woman and her doctor anymore. Now it's with a woman in the state legislature. So I do think this is going to have a tremendous effect on how women vote, because I think there are a lot of women who may have voted one way because there's no way that they thought that within their lifetime Roe would be overturned.
Well, and kind of going along with that, I was thinking about it earlier, what some of the immediate effects are going to be once this law goes into effect. And what I was thinking about is, you know, it leaves a lot up to a physician's judgment. But are we going to have cases going through the chancery courts where somebody wants a declaratory judgment action to say that this is medically necessary?
Yes.
So as far as, I think that I've really been thinking about this. When physicians do procedures, or nurse practitioners or whoever are doing procedures in hospitals, the way the government knows they did that procedure is based on the ICD-10 codes. Those used to be, or DRGs, they used to be ICD-9, you know, it changes every couple of years. But so when you code for an actual abortion, it's one code. It's an abortion over, you know, I can't quote it because I hardly ever see it, but it's an abortion over so many weeks, and then there's a code for an abortion between these weeks, and then there's, you know, you have a procedure for a DNC. So the codes even that they have built currently for an abortion at different terms, or a spontaneous abortion, or a DNC, or these different procedures are different codes. So when the doctor's communicating to the government of what they have done, they're already communicating, saying, hey, we did this, we did something different. We didn't just do an abortion of a baby at 32 weeks if, you know, what they really did was remove an ectopic pregnancy. So they're already communicating that, and I don't see that changing off of this decision. You know, to get the ICD codes changed takes the government years anyway. So, I mean, there's already communication there of what's going on from the physician. So the government already knows what the physicians are doing in these cases. I mean, it's already kind of tricky there, right?
One thing that so there's a couple of viewer questions that came up that we can talk about. One was specifically to our area with Blue Oval City. What would be the impact to businesses that were considering coming to Tennessee that now may not? Because there's been a big movement in the corporate level with companies siding with one side or the other. And I mean, obviously, I think we would all agree that obviously this changes if it's a private company and they don't want to look like they support this Roe v. Wade overturning, that they're not going to come to Tennessee. So, but then the other one that we could give a little more comment on, and I think it's really a private business question. It sounded like, but the viewer said, "What corporate paid travel for reproductive rights? What does corporate paid travel for reproductive rights gets me?" And she said, "Does it also entail IVF cost or just termination?"
So I mean that's going to depend on how the contract is written.
Mm-hmm.
I looked at a few of the articles about that, and a lot of them are, we will pay for healthcare travel, including abortion. So what it's going to have is just like any other kind of insurance. It's going to be, here is a list of, we'll cover this excluding these procedures. They're probably not going to pay for you to go to, Los Angeles and go get Botox in your forehead unless it's medically necessary. But if you need an abortion and it just happens to not be available in Tennessee, depending on what the exclusions are, it may be possible to go to the next state over that does it. And I believe that would be South Carolina probably.
But I think they would be prosecuted. I mean, if it's going to be, depending on if it's a criminal offense, then and a woman seeks one, I mean, you're looking at, she's committing solicitation, and then what about the company? What about the people who are allowing her to go do this? I mean, that's what I'm saying. I think there are unintended consequences of this that even go beyond abortion. I mean, this goes to the heart of right to privacy, and a lot of these cases that Alito, alluded to in this opinion, we have relied upon, and I think that our Supreme Court was very, very disingenuous when it said that, this right to obtain an abortion it was not part of a broader entrenched right that's supported by other presidents that people now rely upon. I don't think that's true. I think that we've had this for 50 years, and then now you're saying, okay, it's not going to exist. This is going to change a lot. I think it's going to change a lot of women's health care.
Yeah, regardless of how I feel about it morally, personally, my question to Jerry was, why didn't they let people, like, if they would have said, hey, we're probably going to do this year, states put some stuff in place, like, you need to get your act together.
But that's not what they do, though. They viewed it as, again, I just think they were correcting the ship, and it's not, let's create more stuff or cause more, look, this is what's presented to us, because you can't just, a lot of people think, well, why hadn't the Supreme Court ruled on, let's just say as an example, why can't I have a tank, or something like that, gun rights issues, right? So why haven't they done that? It's because it hasn't been brought before them properly, and then when it is, it's a limited question that they answer, and then they answer the question, and then they shut up about it.
Having Brian Huffman in this room is like watching an MTV pop-up video. I don't
Jeremy,
know if y'all can hear him.
you were going to comment on something.
Kim's issue, you mentioned them going across state lines, and that might be solicitation or something along those lines.
It could be something, I don't know.
It was actually addressed briefly in the opinion. And what they basically said was states legislating something like that, and that was a concern, I believe, when Tennessee passed theirs at one point, that there was a risk that they were going to put something in there that crossing state lines for an abortion would be grounds for prosecution. All right, so that was addressed in the opinion, and basically the argument would be that would be a violation of what they call the Dormant Commerce Clause. You can't stop people's right to travel, and you can't regulating commerce between the states is up to the federal government, not the states.
Well, I hear you, but this is what I'm going to get at. Doing family law, when am I going to get a case from some man saying, my girlfriend is getting an abortion, and I want I want access to the baby, and I don't want her having an abortion. I mean, it's going to happen.
I've been making that argument for 8 years.
Yeah,
Yeah,
there's a whole other argument there on the
could
man's
be,
side.
But here's what, and I understand that. But what I'm getting to is, will we have, couples who will be seeking some sort of criminal action for someone who states that they're going to do this? I mean, threatening to do it even. I mean, it's just I think this is going to be a lot more complicated. And when you look at it going back to the legislature, Tennessee isn't, we're not as forward thinking on a lot of stuff. I mean, we still have some things in family law, that seem to be a little archaic to me. Like, if you're pregnant, you can't file for divorce. I mean, you can file for divorce. You can't get a divorce if a woman's pregnant. Okay? You can't. I know that there are family courts out there that will not let women go back to her maiden name because they say it's going to bastardize the child. And stuff like this happens all the time. I'm saying that we're not going to be able to see what the effects of this are going to be. And I'm just playing devil's advocate. I have my own thoughts on everything, but you got to have somebody here who's going to say the other side sometimes.
Well, you mentioned that, the opinion said, and if you can find it again, that'd be great. If not, it's all right. That the right to an abortion doesn't necessarily directly affect any other right, and you disagree with that.
Well, I'm not saying I disagree that it's going to affect any other right. I'm saying that we have a whole litany of right to privacy cases that were decided that now are up for debate. And I do think that some of those could be contrived. And here's why I say this. I go back to the politicizing of the court. The groups that have strongly advocated for Roe to be overturned, they have done this very well over 50 years, and they have put a lot of money into this cause. And I think that the other side is sort of taking it for granted that this was a right that would just be there forever. And they have lobbied very well. So a lot of these things that happen are well-funded efforts. I mean, that's just a fact in our American political system. I do know it's on both sides. That's why I'm saying, and I've talked to you before, I don't like the politicizing of all of it, because I think the average American citizen is not on either end of these far fringe ideas. I think that the body of Americans are pretty solid and are pretty reasonable when it comes to things. But I think that the way all of these issues have become so politicized that we're just not being well represented.
You do understand that the court has always been politicized.
Oh, of course I understand that.
The classic switching time to save 9.
Sure.
Is FDR, who was court packing to get his own agenda pushed through.
Sure.
Well, but as a healthcare worker, I really go back to kind of what you guys were saying about there'll be disparity, it'll be a rich person, poor person.
There will be.
So I go back to what is going to limit somebody's access to health care, getting them in the door, right? And what are we going to see down the road because people are scared of being stigmatized for whatever that is,
So my main issue with the whole thing has been, you have one side that has rested on Roe v. Wade and Casey. We had the Hyde Amendment back 15 years or so ago that disallowed use of Medicaid funds for abortion. It's what people reference when they say that Planned Parenthood cannot use government money for abortions.
There's no money for that.
Right? But the 14th Amendment, which is what this all lays on right now, it says, no state shall make or enforce a law which shall abridge the privileges or immunities of citizens in the United States, deprive a person of life, liberty, or property without due process, or deny any person within its jurisdiction equal protection. That's Section 1. The next 3 sections are about Congress, getting paid, all that kind of stuff. Section 5, though, is where people forget. It says Congress shall have the power to enforce by appropriate legislation the provisions of this article. So we're relying on 9 people in robes to make these decisions and ask them to last for 50, 75, 100 years when Congress is specifically given the job to pass laws to make this happen?
Well, I agree, but the point is that we still have a legislature that may or may not pass laws that people are really want maybe necessarily. I feel like it's going to be up to, I think people need to be more involved in the political process. I mean, and we've just taken it for granted that some of these rights are there.
It's easy to put something off on somebody that can't get kicked out of their seat the next election too than it is to actually put your money where your mouth is and go to bat for something that is the unpopular decision. So I can appreciate where they fall on it.
So I'm going to start summing things up from my perspective a little bit so you guys get your thoughts together because we're working past an hour here. I do want to thank everybody that has watched us today, and please feel free to comment. I'm sure we'll all check the comments if there's any specific questions that we didn't answer. My big thing, like I said from the beginning, was that I wanted to just address how this occurred and then sort of to help hopefully control people's fears about what doors it's opened. And I think to some degree we had. Like, honestly, I hadn't even thought of the equal protection argument that Jeremy had brought up, but I think some of these other cases are a little safer because of that, so that may give people a little more solace. But ultimately, the thing is, like, look, whether I'm pro-choice or pro-life, we're all human here, and we need to have open discourse on the differences of opinions in order for us to learn from each other and hopefully reach some consensus one way or the other. And I don't hate anybody that's on the other side of the aisle either way. Sometimes I don't agree with them, but I try to be open-minded to their perspective. And what I've learned too, as an attorney especially, and then just dealing with people, is that it's very important to listen to the other side's argument. One, if you want to poke holes in their argument, you got to listen and hear what they say. But two, even if you're trying to change their opinion to your opinion, you've got to hear where they're coming from. You can't just you can't post stuff on Facebook of, well, this is my right, or this is not, or, you love the babies and all that kind of stuff. You've got to understand the reasoning, because most of the people are not bad people. Most of these people out here, the people that are pro-choice and the people are pro-life, they both love families, they love people. I don't think any of them are trying to kill babies, nothing like that. So the real issue that I'd hoped is we could come to and we all have different views on it. Now, we haven't really voiced personal opinions on it, but I'm sure we all have different views on the actual topic, and I just hope that everybody can be respectful to each other and other people's views, and there not be a lot of drama and violence and stuff associated with it. So I do want to thank each of you for coming on, and then I'll give you a second to do your last few thoughts here on what you think. If there's something else we haven't covered you think the viewers should know on this. Madeline? Nothing?
I'm good.
10th Amendment.
Okay. Brian, drinky drink.
Jeremy?
Well, ultimately, I think this just shows people how important it is to get involved beginning at the lowest level of government. That is where most of the decisions are made that primarily affect your life. The elections that we have in Tennessee coming up, and the ones we'll have in 2 more years, are going to be the people who make these laws regarding abortion. This decision's not going to get overturned anytime in the next 5 years. So this is what we're going to be dealing with for the next several years. So the only way we're going to be able to affect it in any way is to legislate on the state level. And whether you're anti-abortion, pro-life, pro-abortion, pro-death, however people want to phrase things, it's time at this point to get involved if you have a strong opinion about it, and let your legislatures know how you feel, because they are funded by massive corporations and people with a lot of power, and a lot of times the people on the street don't necessarily feel like they get heard, but it's time to make sure you get heard no matter which side of the aisle you're on.
Thank you, Jeremy. Kim?
I'm going to raise the alarm. No, I'm just kidding. No, I
Gondor calls.
Yeah, I do see where the court made their opinion based on this was not their job to do, and that's basically what they said. They said it's not our job. It's really your legislature's jobs to regulate this or decide. So I just, for me, I'm very much, you do you, I do me. And I don't fit any political category. In fact, anybody who talks to me will know I'm not I don't trust the government. If the government says they're going to do something for me, I usually say run. But, what bothers me is this idea of right to privacy. I think there will be some unintended consequences of it. And I made a joke with someone today at court, actually. I said, I feel like this is all like a ruse to deflect us from something else that's going on. And I don't mean to sound like a conspiracy theorist or anything, but
January 6th hearings.
Yeah.
Maxwell
Not
sentencing.
anything like that. But it does bother me that we had this that was conveyed and then it was taken. I do like the idea, and I think the legal principle of stare decisis is important. That's what that's how we go to court every day, because we say, hey, this is what, the statute says, or this is what they've ruled, and this is what we know. So we base our arguments on those things. So to overturn it like this is difficult. I also have a problem because, this is a woman's body. And, somebody may decide something I may not decide, but I'm not sure if I feel comfortable leaving that to each state, only because it wasn't within my lifetime that schools had to be purposely desegregated long after Brown v. Board. Sometimes there are decisions that have to be made because they're the law doesn't mean that people are going to follow them. So it's one of those things that I do think that we are going to have some fallout and some unintended consequences of what people think was the best thing to do. And I think that there are going to be consequences we're not ready for.
And if you want to read the Supreme Court opinion, it is about 213 pages, the size of a newborn baby.
Yeah.
It's this right here.
So if you really need to go to sleep tonight, start reading through
It
that.
was interesting.
I don't know. You say that. Jeremy reads that stuff for fun.
You do. You and I read all this. We nerd out on it. I love it.
Madeline?
Yeah, I changed my mind. So I would just leave with that everybody was already at stress max capacity post-COVID, right? And I think that for a lot of women and a lot of men too, this has heightened stress. And
Yes.
it has, and sometimes that stress can feel burdensome and insurmountable. And I would just like to encourage everybody, if you feel that way, talk to somebody about it, Talk to your friends. You have friends that are like-minded in the matter, even friends that aren't. And don't suffer in silence. Don't go, all day long and feel bad about the way you feel about these things. But you can have a conversation with other people about it and not have to argue with people about it. I can disagree with Jerry and not have to argue with him about often, and not have to argue with him about it, but he can support my feelings and I can support his feelings even if we do disagree on certain topics. So I think it's really important to know that this is something that doesn't have to divide people further. It can bring people together and people can support each other regardless of their stance on this topic. We don't have to be isolated from one another or feel distressed about what's going on. And maybe, you feel one way or another, you talking with other people and sharing your stories and your opinions and why you feel the way you feel can change their mind too. So I think it's important that we learn from each other.
And Jerry, could we please say, we don't advocate either side of this. This was just a purely legal, just arguing or just even talking
Kim,
about
it's
it.
all right
which I
to
think is
admit you're
good.
wrong.
What?
They said it's all right to admit you're wrong.
Hey, I came on. Listen, we agreed earlier. I actually am not far off, but we got nobody over here going through it and try to thumb through it to bring up some other stuff. So you've always got to have somebody who's going to play devil's advocate. I guess it'll be me today. I'm sure it'll be you next time or something.
Well, I do appreciate y'all taking the time to come on. Jeremy is he practices through West Tennessee too, but Lauderdale, Tipton, I think mostly, and he's available if you guys need any legal assistance. And then obviously Kim's my law partner is here. Or like I said, if it's specific questions on this issue and we didn't address them, we'll follow up. Feel free to comment below. Some of you already have. If you have any other questions, we would be glad to answer them. Madeline too. So thank everybody. I want to thank all the people that were on the panel. If you guys liked this style of interview, I have a challenge I'm putting out. I want to moderate the Covington mayoral debate. I've already addressed a couple of the candidates. There are now 3 that have thrown their hat in. And if you guys think that's a good idea, you just let me know and we'll get it set up. And I could do it in this format, or I'm even open to do it in a big public forum where everybody can watch it. So anyway, I do appreciate you guys taking the time to watch this. If you think that somebody would benefit from this, share it with them. Again, I did this more out of because I want my daughter to know she is very loved, even if she and I differ on many different issues. And there's a lot of people that I'm sure you love that are struggling with this. And I just wanted people to, maybe this could calm them down and ease the tensions a little bit. So if you haven't already, please follow us. You can subscribe to us across podcast platforms. We'll be live tomorrow with another Law Talk. It's always Tuesdays at 5, and then sometimes I do these special ones. I'm also on TikTok. Josh likes to get on there and dance, so you can watch the TikToks.
I'm not dancing.
He's dancing all the time. Anyway, and then Covington Comic-Con is returning to Covington Civic Center August 20th through 21st. Whoops, that's me. And if you're interested in being a vendor or sponsor for that event, please go to CovingtonComicCon.com. I want to thank Michelle Allen. She's a longtime sponsor, local realtor. Michelle, I finally got the mic stands. These are the mic stands, so she'll be excited to know that we finally got those set up. If you'd like to become a black belt or Kickin Lawyer yourself, you can visit Mason's High Octane Martial Arts, located in Covington. Been there since '93. We'd be glad to have you jump on and go start your own black belt journey. Don't forget the cellar. It is open 4 o'clock every day. Monday, Tuesday, Wednesday this week, there's a happy hour from 4 to 6. And tomorrow I'm doing a trivia tomorrow. So make sure tomorrow you're there for the trivia competition. I forget what time it starts. It's on the website, but check that out. And then, of course, if you need help with your digital marketing and branding, Josh would be glad to help you at Masonite Digital Marketing. So, again, I thank you guys. We'll be live tomorrow with a pro wrestler. Is it Bam Bam Bundy? Is that right, Josh?
I think that's right.
Yeah, so you better be there or be square, brother. Keep kicking.